In episode 12 of the Supreme Court Opinions Read podcast, I'll be reading the Supreme Court's opinion in Doe versus Dynamic Physical Therapy. Case was decided December 8th, 2025. And in this case, there is no syllabus, so we'll move right on to the opinion, which was written per curiam. Louisiana immunizes healthcare providers from civil liability during public health emergencies. Below, the Louisiana Court of Appeal held that this state statute barred plaintiffs' federal claims. That decision is incorrect. Defining the scope of liability under state law is the state's prerogative, but a state has no power to confer immunity from federal causes of action. See, for example, Howlett v. Rose, Haywood v. Drown, and Williams v. Reed. The judges in every state are bound to follow federal law, anything in the Constitution or laws of any state to the contrary notwithstanding. Plaintiffs' federal claims may well fail on other federal grounds, but that is for the Louisiana courts to decide in the first instance. The petition for certiorari is granted, the judgment of the Louisiana Court of Appeal is reversed, and the case is remanded for further proceedings not inconsistent with this opinion. It is so ordered. And that is it for the opinion. Extremely short one. Literally the PDF for this decision that I was reading from is 1 page long. And yeah, it seems pretty obviously correct to me. The states can't violate federal law. That's just the supremacy clause. Plain and simple. Now, an interesting thing about this case is that it seems somewhat similar to a case that you may remember we covered fairly recently, Williams versus Reed, and Williams versus Reed was decided 5-4, 4 justices in dissent, and you may remember I agreed with the dissenters in that case, or at least Justice Thomas, because the Thomas wrote the dissent and the other dissenting justices signed on to part of his dissent, but not the whole thing, and I agreed more with the part that they didn't sign on to, whatever. You can go back and listen to that episode if you want my full thoughts on it, but anyway, the point is, the two seem kind of similar, but this was decided unanimously, and, very, almost summarily, right? It's just a 1-page decision, per curiam decision, and in this case, I agree with the opinion of the court. So you might ask yourself, well, why? Why the difference there? And I think there's some distinguishing factors between this case and Williams versus Reed, which is that in Williams versus Reed, it seemed, at least to me, and at least to Justice Thomas and perhaps the other dissenters, that what the state was doing was just setting out the jurisdiction of its federal court, or of its state courts, which it has every right to do. It was not conferring an immunity to a federal cause of action. It was saying our courts can't hear this federal cause of action or this federal claim under these circumstances. And the states are totally allowed to do that. Nothing in the Constitution requires states to provide a forum for hearing federal claims or enforcing federal laws unless a federal statute validly imposes that duty on them, which the statute at issue there, Section 1983, did not. Here, though, that doesn't seem to be what the state is doing. They're not saying our courts aren't going to hear these federal claims. The state is saying we are conferring immunity that does not exist in the federal statute from these federal claims under these circumstances. And that the Supremacy Clause definitely prohibits. That is, in conflict with the federal law. The federal law says, these people can be sued for these claims by these other people under these circumstances, and the state adds a caveat to that, a carve-out to that of its own, saying, except under these circumstances. Then we confer immunity to, XYZ people. It's in conflict with federal law. Supremacy Clause says you can't do that. And so that's the basis, I think, for the difference between this case and Williams versus Reed is this is not just a jurisdictional statute. This is plain and simple an immunity statute. So yeah, I think that is about all I have to say about this case. So, if I may ask you, my friends on the other side of the screen, please like, share, comment, follow the podcast wherever you follow podcasts, and if you'd like to support the show, you can do so on Patreon. The main content of the show will, of course, always remain free, but Patreon members have access to episodes early and any bonus or exclusive content, and they can request specific content, including other than reading Supreme Court opinions. With that, tune in for the next episode where we will be going back to our trek through the Supreme Court's 2024 term. Until then.